World. Welcome to the launch of the OECD-IDB peer review of Ecuador's competition law and policy. A joint effort. We also welcome those that follow us from different places in the world, specifically Mr. Lenin Morcelo Garces, President of Peru, Madam Adriana Lavalle, IDB representative in Ecuador, Mario Ubaña, lead trade and competition specialist of the integration and trade sector at the IDB, Mr. Felipe Irarrázaval, director of the competition center at the Adolfo Ibáñez University. He served as a consultant in the preparation of the peer review of Ecuador's report. Mr. Frederick Jenny, chairman of the OECD Competition Committee, Mr. Danilo Silva, superintendent for the control of market power. To begin with the event, we will give the floor now to Madam Adriana Lavalle, IDB representative in Ecuador. Madam, you have the floor.
Por favor, pedimos a Adriana Lavalle, representante del Banco Interamericano de
Madam
Desarrollo.
Adriana Lavalle, IDB representative in Ecuador, please, you have the floor.
Gracias. Buenos días con todos los asistentes.
Thank you very much to all the people who are present. As a representative of the Inter-American Development Bank, it's a great honor to be here participating in the presentation of this peer review of competition law and policy in Ecuador, which has been carried out by the Organization for Cooperation and Economic Development, as well as together with the IDB. It's very satisfactory to be able to see the results of this project, which was carried upon the request of the Superintendency for Market Power Regulation in 2020, and which was also discussed in the Latin American Caribbean Forum for Competition last year. We trust that the findings of this study will give the country the chance to be able to align its policies to the highest international standards for free competition and thus foster markets who are more efficient in benefit of consumers and users. For the IDB, job recovery and economic growth in the region support, and we hope that this study will contribute to obtaining that objective by supporting a better investment climate and an increasing productivity. After the presentation of the study, we will go into the most important stage, which is the actual implementation of the recommendations. And I would like to say right now that you can count on all our support in that step. Thank you very much.
Agradecemos, Adriana.
Thank you, Adriana. Let's move on now to Mr. Mario Umaña, lead trade and competition specialist at the IDB. You have the floor, sir. Good morning, everyone, and welcome to our colleagues from the Superintendency, from the OECD Secretariat, our colleague Felipe Irarrázaval that work in the preparation of the report, and welcome to all the participants. As our representative in Ecuador just mentioned, we are really excited about the presentation of this peer review of Ecuador's competition policy carried out in 2020. Ecuador joins 10 other countries in the region that have been subject to these reviews over the past 17 years on competition through a tripartite collaborative mechanism between the bank or OECD partners and the assessed country. The peer review is the heart of the joint work that the OECD and the IDB do on competition issues, and it is normally carried out within the framework of the Latin American and Caribbean Competition Forum that we organize once a year. The extraordinary thing is that the review is done by peers, not just agencies or bodies. i.e. other jurisdictions within the region and from outside the region. In this particular case, the reviewers were the competition authorities of Canada, Spain, Panama, and Uruguay. And we'd like to thank them for their job. Peer review can be described as a systematic review and evaluation of a state's performance and evolution by other states, with the ultimate objective of helping the state under review to improve its policy development, to adopt best practices, and to adapt to established standards and principles. They are then friendly reviews based on mutual trust between the states participating in the review and on the credit given to the review process. When the peer review is undertaken with the support of two international organizations, as is the case here, OECD and IDB, the chances of success increase. For a peer review process to be successful, at least three elements are required: willingness of the host country to undergo the evaluation and to implement the recommendations, funding of the process, and technical support. We obviously have the three elements here. We have a clear leadership of the SCPM. They have shown a great openness in this process. We also have the funding from IDB and the technical support coming from the OECD Secretariat, in particular the Competition Division, and more specifically with the support of the chair of the Competition Committee. The protection of competition, as our representative was saying, will help Ecuador's economy to achieve higher growth through higher productivity rates, while the consumers will enjoy better price and quality conditions. We extend our best wishes for the SCPM to take on board their recommendations and to implement them. Thank you.
Agradecemos la participación de
We're
Mario
very
Humana.
grateful for the participation of Mario Umaña, and now we would ask Felipe Irarrázaval, a consultant for the drafting of the peer review report for Ecuador. Go ahead, please, sir.
Muchas gracias.
Thank you very much. Thank you very much for the invitation to be here. I'm trying to put my slides up here. I'm not sure whether or not I'm able to do it. There we go. You can see it now, can't you? Yes, we can.
Muchas gracias.
Well, thank you very much then. First of all, I'd like to say that I'm very grateful, just as Mario said, for the availability of the superintendency during this peer review, which was a very difficult point in time in the middle of a pandemic. And I was quite impressed by the professional work done by the entire team, especially by the superintendent and by Gabriel as well, with whom I engaged in a lot of the coordination of the peer review. In these few minutes I've got, I would like to be able to, and it's not very much time, I would invite you rather to read the document actually, but I would try to summarize, if possible, in just a few minutes, what would be the main challenges that we in our team were able to identify in the situation in Ecuador with competition. So first of all, I would repeat what Mario said, that the process itself, a peer review process, is a very demanding process. I would even dare to say it's the most demanding process that an agency or a country can subject itself to in terms of competition. One indicator of that is that if we take a look at this specific case, I'm sorry, the speaker's video and audio is cutting out for me. 25 persons and associations, including universities as well. I won't waste too much time in talking about the actual people involved, but it was a very long list. But I would like to say that we're very grateful to them, without whose help we wouldn't have been able to do this work. So there was questionnaires, surveys that are sent out, which follow OECD formats. They were answered by the authority. And then the report itself is written up, it's drafted, in which Cristina, Jordi, and Rosario were all participating quite actively in that. Many different draft versions, drafts of drafts, trying to summarize the information and be as clear as possible. And as Mario said, there was a meeting of the OECD reviewers, and then with the agency itself at the very end before we come up with the final report. So to talk a little bit about what we've seen within the report itself, there are a few things that are quite clear, that the law we're talking about here is quite recent. But despite the fact that the law is very recent, so that Ecuador took quite some time too, in fact, was one of the last countries in the region to adopt a competition law. It's a very complete law. It assigns a great deal of power and authority where needed, and that makes it a complex law, complex to administrate. So there's work to be done there in trying to implement, to carry out these attributions of power in a way which is complete, deep going, efficient, effective. So it has wide going content with revisions from 2012 that in some ways go away from the original law. It has a system of fines, which is very pertinent, having to do with sales, without having some sort of criminal sanctions. That is to say that it follows more of a European model. And the superintendency, and this is something that we can see by the fact that this is a new law, it's a young superintendency. It's a young agency just created in 2012. And like all young agencies, it has the challenge of having to improve its technical profile. And to talk about the technical profile, there's also the issue of the independence that the people who work within the superintendency need to have independence to be able to take decisions, of course, using technically justified arguments. And this is something that we saw, those of us who worked on this peer review, that the current administration has placed a certain focus and emphasis, has made efforts in increasing the technical profile and increasing independence. But this is nevertheless something that is work that always has to be done. There's always risk involved. Every country has to always take a look to make sure that they don't somehow distort the institutional nature of the independence. And the role of the superintendent is rather complex in Ecuador. There's the possibility for that they can be assigned or they can be designated by the administrative council, and that sometimes a political argument should not be able to be used for that. There are some 200 civil servants working within the superintendency, 50% of them in enforcement, and the rest are in support. This is rather a large amount of people in support functions. We would hope in the future, and we've already seen, in fact, that things are moving in this direction, that in the future, the proportion will increase in terms of economists and lawyers that are working on the particular cases. There's a high turnover, so there's a challenge involved there in trying to keep a type of stable bureaucracy within this organism because the technical work that it involves. There aren't many civil servants working in abuse of power and cartels. And this can happen sometimes in the new agencies. And there's also not a chief economist, which is something that other agencies of the region and the world do have. To say a bit more about the superintendency, the great challenge, in our opinion, is prioritization and emphasis or focus, choosing well, choosing good cases. Institutionally, who really decides about these cases is a commission. There's a commission that decides, and this commission should be as independent as possible, even independent from the superintendent himself, and should be given proper resources and professionals to be able to actually fulfill the demands that the law stipulates and in the timeline stipulated by law as well. There are budgetary restrictions as well, but this is something that one can see in the whole region, all the world, that competition agencies are fighting to maintain, to keep their budgets. Of course, there's the same financial problems that have been affecting the countries because of the pandemic that are to be found all over the place. But it would be very positive, it would be favorable to assure a midterm or long-term budget which is reasonable in nature and which does not decrease halfway through the year, as we've seen has been happening in Ecuador habitually. And there's a challenge there. And this is one challenge that all of the agencies in the regions face, to try to incorporate best international practices. In my opinion, the best place for incorporating those practices, for understanding them, for understanding solutions, is in the OECD. So I think the step that Ecuador has taken, and the Ecuadorian agency, to subject itself to this process is extremely pertinent. What about application or implementation? Well, there aren't actually very many cases. There's a challenge in coming up with successful cases, strong cases, ones that have been able to deal with all the different questions that might have come up, including appeals that might have come afterwards in other courts. So if we look at the superintendency from the very beginning, we can see that there is a lot of investigations opened, but not many that were actually closed successfully. There have been many either annulments or reversals or cancellations. There's others that, because there's a certain ones that had a problem with the economic dependence as well, which we don't understand if there was a lack of sanction. And in front of the cartels, there's also been very few cases if we take into account the time that they've been around. And they also don't have very high fines. And many of them, of those cases with cartels, have finished with a compromise rather than with a ruling that would somehow set some sort of precedent. In terms of mergers as well, it's been functioning in keeping with international practices. And there are some things that could be improved. Things can always be improved in terms of fusions or mergers, mergers. And in terms of unfair competition, this is something that normally is analyzed by a different type of organism in other places of the region. So, but unfair competition is something which comes very close to issues that are actually more directly related to consumer issues. And when we talk about advocacy as well, promotion or advocacy, we need a certain focusing as well. Often there's, sometimes with competition, less is more, but that less needs to have, has to be very important in terms of what we choose. So market studies, for example, there's a lot of market studies, reports, guidebooks, manuals. There's too many of them sometimes, so it's clear that there needs to be a certain focus here. In terms of other agencies or authorities, well, there are that are involved in this process. That's normal. There's a regulatory board, for example, that exists as well. And we've seen that there's a certain duplication or an overlap of the mandate between them and a certain inactivity compared to the superintendency. And as also happens everywhere in the world, ordinary courts don't have the same specialization that competition bodies do. And so there's a learning curve that happens there to make sure that those courts actually acquire the expertise that is needed in the application of competition law. And within their understanding thereof, can increase the number of rulings or sentences that are issued. In terms of procedures, obviously there's a challenge in meeting procedural standards. This is a very intense work where the authority can have access to a great deal of confidential information must be extremely careful in fulfilling the high standards, not only procedural standards, but also substantial ones as well. Because these regulations, of course, must expect investigation timelines as well, which demands upon the authority to be able to take decisions that must be reasonable in a very short period of time. And in terms of we've also, it would be preferable that they use the international experience as well for cases that are perhaps not more important and learn how to deal with them. And up until now, something that's been the crown in the jewel of many jurisdictions. In the case of Ecuador, they've not been able to actually get a proper leniency program off the ground in a way that would be efficient and effective. We're hoping that in the future, that tool could actually be used more habitually. There are some issues related to confidentiality as well, which obviously is something that's extremely important when talking about the private sector. Confidentiality exists thanks to trust between private stakeholders and of the business world and the country's administrative authorities. So there is a need, and this might seem contradictory, but we need to make sure that confidentiality and publicity are made compatible. And the history of the superintendency, we've seen that they could have been more demanding in showing actually what rulings had been adopted. And this would have an important effect on the entire sector that's being regulated, not only those who are participating in that particular case. The Andean court as well has, there's an interesting case where there was intervention by the Andean court with a case of paid leniency, and there was that area of also respecting the powers or authorities between these different authorities, be they the superintendency on one hand and an intra-regional authority on the other hand. And then a last issue, which is one that still has to be dealt with throughout the entire region and many other jurisdictions of the world, which as well is compensation for damages. And this is something, because this is a fine that is applied to those who are completely directly affected. So to create a true virtual circle, we need this tool, compensation for damages, and this is one. This is going to be more important when there are cases involving abuse of dominant position and cartels and such cases. So thank you very much for your attention.
Muy amable por su intervención. Continuamos con el señor.
Thank you very much for your intervention. Let's move on now to Mr. Frederick Jenny, Chairman of the OECD Competition Committee. You have the floor, sir.
Mr. Superintendent, representatives of the IDB, ladies and gentlemen, it's a great pleasure for me to attend the launch of the OECD Competition Committee peer review of Ecuador and to report on some of the most important recommendations of this peer review. And before I start, I want to thank Felipe, who's done an extraordinary job of analyzing the situation in Ecuador and helping us find our way during this peer review. So let me start by just reminding everybody of the importance of competition and why we are gathered today. Competition forces firms to lower the cost and to improve their efficiency to attract consumers. That's the first point. The second point is that competition, economic competition, pushes firms to innovate, both in terms of production processes and in terms of new products, in order to differentiate themselves from their competitors. And this is good for innovation and progress. And the third point is that competition eliminates monopolistic rents, which are taxes on consumers, and forces firms to pass on to consumers the benefits of their increased efficiency. These three elements contribute to economic growth and development and to the welfare of consumers. Now, competition is clearly a constraint on the strategic behavior of firms, And they will have a tendency to try to eliminate those constraints, to suppress them, by engaging in anti-competitive practices if they can. And this is the reason why we need a good and effective competition law system. Now, you've heard from previous speakers the peer review process. I think it's a very important process because it helps countries to improve their laws and to meet international standards. What is important to understand is that the recommendations which are formulated in an OECD peer review are simple suggestions made for the benefit of the peer-reviewed countries and based on the common experience of the OECD countries. It's also important to remember that the effectiveness of a competition regime needs to be assessed in the context of the economic, administrative, and legal context of the country in which it is implemented. Thus, there is no one-size-fits-all answer to what is a good competition regime, even if the past experience of a large number of jurisdictions can be useful to guide and a useful guide of what may succeed or fail. Finally, and linked to the previous observation, all countries have found that a competition regime needs to be tested to assess how it can be improved. And over time, in each OECD country, there have been a number of amendments of the existing laws to improve their effectiveness or to reduce the cost that they may impose on market participants. Thus, the fine-tuning of a competition regime is a normal evolutionary process. Now, the peer review that, and you've heard Felipe's analysis of the situation, this has led the OECD Competition Committee to make a number of recommendations. I will not be able to go into all of those, but I would say first that they fall in three general categories. Recommendations about the substantive law, organizational recommendations for the superintendency, and systemic recommendations. So with respect to the substantive recommendations, let me first congratulate the government of Ecuador and the superintendency for the reform of the regulation for the application of the organic law for market power regulation of November 17, 2020. The reform addresses a recommendation which was made in the report with respect to the adoption of a two-phase system for the analysis of mergers, which would allow a sharper procedural distinction between the mergers which are problematic and the non-problematic ones. The reform also addresses, to a certain extent, an institutional recommendation of the OECD report regarding the clarification of the respective roles of the superintendents and the regulation board. The fact that those reforms were implemented very shortly after the peer review and their consistency on the points I just mentioned with the recommendation of the OECD peer review is, I think, a testimony to the commitment of the superintendency and the government of Ecuador to improve the effectiveness of the Ecuadorian competition law system, and also to the contribution of the OECD peer review process. Now, let me turn briefly to some of the other recommendations in the report and put them in context. First, recommendations requiring possibly a change in the legal framework. So there are recommendations on the substantive notion of abuse of market power, and in particular, a recommendation to revise Article 9 of the law on abuse of market power. There is in this Article 9 a non-exhaustive list of specific conducts, which is long and contain duplications and redundancies, and also the conditions attached to the listed conduct seem somewhat inconsistent. So this list should be clarified and simplified and harmonized across the various examples of illegal conduct. It is also recommended to delete Article 10 of the law on abuse of economic dependencies. The law doesn't provide sanctions for this infringement. In addition, it is unclear whether the conduct to be unlawful must be undertaken by a firm which has a dominant position on the market or only a firm which dominates the victims. So it would be probably best to delete this provision and only investigate relevant cases under Article 9 on abuse of market power. A third recommendation concerns merger control, and that is a recommendation that to trigger the notification obligation, at least two participants in the transaction should exceed a certain turnover. The law at the present time provides that a merger be notified if the turnover of the group of participants exceed a certain turnover. Thus, a transaction needs to be notified even if there is only one participant which has a significant turnover in Ecuador. Now, that means that a very significant number of mergers, transactions which have no or very little impact on competition in the country would have to be notified. For example, that would be the case if a very large firm would buy a very small firm or would buy a store. Well, that would not have a major competition impact on the country, but it would still have to be notified because of the importance of the acquirer. So we suggest that there should be two thresholds, one for the acquiring company and one for the acquired company, in order to make sure that the mergers which are examined and have to be notified are the ones that may have an impact on competition in the country. Now, there are a second group of recommendations with respect to the institutional design and the capacity of the authority. You've already heard that we found that the budget of the superintendent should be aligned to international standards, and it is not aligned at this point. In addition, as you've heard, Ecuador should ensure that media budget reductions are only done when it is strictly necessary and that they are proportionate and non-discriminatory. Now, it's quite clear that the lack of resources reduces the possibility of investigations and the possibility of advocacy efforts that the agency should carry out, and ultimately these affect its performance. There are a number of references of countries which are in a similar situation as Ecuador, by size and by economic development, and an alignment of the budget of the superintendency on those would be very useful. A second recommendation is that the first instance resolution commission should be empowered and independent from the investigatory team of the superintendency. The first instance resolution commission is composed by 3 commissioners, which are appointed by the superintendent. They adopt decisions that are subject to an internal appeal before the superintendent, as well as a possibility of appeal to the judiciary. Well, there are 2 issues there. The first one is that the commission, the resolution commission, doesn't have the resources to study cases in depth to ensure that its decisions are fully informed. But the second issue is that there are concerns that this commission, made of commissioners appointed by the superintendent, is not entirely independent of the superintendent and therefore not entirely independent of the investigatory units of the superintendents. Now, it is a principle in many countries that investigation and adjudication of cases should be made by separate and independent bodies. Now, let me turn to recommendations with respect to the enforcement and merger control activities of the superintendency. The first recommendation has to do with the specificity of the law in Ecuador and deals with the relationship between provisions on unfair competition and provision on practices which restrict competition. In many countries, there is usually a distinction between unfair practices, which are practices which are dishonest, I would say, which may hurt another firm or a consumer, and anti-competitive practices, which hurt the competitive process on the market rather than a particular competitor. Now, the Ecuadorian law prohibits acts of unfair competition that impedes, restrict, or distort competition, threaten economic efficiency, or the general welfare, or the rights of consumers or users if the perpetrators has market power. So there are two issues related with this provision. First, the superintendency is only competent for unfair practices by firms having market power, but not competent for other unfair practices by firms which do not have market power. So in a sense, there's a void somewhere. Second, the resources dedicated to the enforcement of unfair competition rules are very significantly more important than the resources which are devoted to investigating anti-competitive practices and mergers. So the feeling of the OECD Competition Committee was that this share should be rebalanced with more resources allocated to the investigation of antitrust cases and fewer maybe to unfair competition. An alternative would be that Ecuador could consider could be the fact that it could entrust the review of unfair competition cases, whether or not the perpetrators have market power, to a separate agency. This change would allow the superintendency to focus on its core role, competition enforcement and advocacy, and also to avoid potential misunderstanding concerning the different objectives pursued by the competition law on the one hand, and unfair competition on the other hand. A second recommendation deals with the prioritization criteria of the enforcement and advocacy activities of the superintendencies. With respect to enforcement, the suggestion was made that the superintendent should assign certain priorities to investigating conducts that are clearly harmful, and in this process, take into account, for example, the market position of the companies involved, whether the affected products and services are important to consumers, whether the number of consumers affected by the practice are important, and finally focus on sectors that are critical for Ecuador's economy, or where there are clear market development, for example, digital platform and e-commerce, and the use of personal data. With respect to advocacy, it is recommended that a superintendency should develop a strategy for its promotional activities. In 2019, the superintendency discontinued most of its past promotional activities, and this made sense. There were too many, they were uncoordinated, and some of them only had a vague relationship to competition law enforcement. So fewer promotional activities made sense from a budget perspective, but also from an efficiency benefit. Currently, the Department for Promotion holds few events, campaigns, and training, and they appear to be much more targeted, which is a very positive development. It is important that the superintendency develop a strategy for its promotional activities, as well as a priority setting for its enforcement activities. In relationship with those recommendations, there's also a suggestion that the superintendency should consider publishing its priorities annually for the following year. This is a practice which exists in many countries and gives notice to everybody of what are the focus, the main focus of activity of the competition authority. This is important for the accountability of the competition authority and for the generation of public trust in the agency, which Felipe was referring to earlier. Within enforcement, there was a recommendation that maybe more human resources should be devoted to prosecution and to merger control. The allocation of employees of the superintendency seems a bit imbalanced compared to what is true in other agencies. Less than half the employees are assigned to the agency's core competition activities, and the remainder work on administrative tasks. Out of the employees working on competition, there are only 11 working on anti-competitive conducts, 5 on restrictive agreements, and 6 on abuse of dominance, and 9 on merger control, whereas 18 work on advocacy. This seems to be a bit imbalanced, and the OECD is very sensitive to the fact that one of the worst possible violation of competition law is cartel, and that cartel enforcement is particularly important. So there was a suggestion that maybe a rebalancing of the resources of the superintendency could be useful. Once a case has been dealt with, there is a recommendation that fines should have sufficient deterrent effects, and if necessary, that the superintendency should impose higher fines than it has done in the past. There is a general recommendation of OECD concerning the effective action against hardcore cartels, which applies to all the OECD countries, and it encourages the member to provide for effective sanctions against violations of the competition law. It encourages countries to use a combination of civil, administrative, criminal sanctions to achieve an adequate deterrent effect. In the case of Ecuador, it seems that even the superintendency, which has the possibility to determine the amount of the fines within the limits set by the law, could increase the level of the fines, because it seems that the fine imposed to date have not had a sufficient deterrent power. And when one combines not enough resources, only few cases that are successful, and fines which are not deterrent, one has a rather weak system. Along the same lines, there is a recommendation to publish all decisions establishing an infringement. This is in the process of being done. There is a digitalization of the decisions of the superintendency, but in many countries, publishing the decisions with the reasoning of the competition authority is particularly important to make sure that people understand what the competition law is all about. Finally, there's a recommendation that Felipe has already mentioned about the continued improvement in the quality of market studies, both from the legal and the economic standpoint. Let me finish with a recommendation on the judicial system. Ecuador has the same problem that many countries, developing or not developing, have. Because competition and enforcement and competition law enforcement are recent in Ecuador, and because the competent courts are courts of general jurisdiction, the judges may not have a specialized knowledge of competition law, nor have had the opportunity to gain this knowledge through studies or case experience in their career. So in Ecuador, as in many countries, the judges lack substantial competition expertise. This is an issue because in the end, the judges have the last say on what the law means and how it should be interpreted. So capacity building of judges in competition law is therefore crucial for Ecuador, as it is, and I repeat, in many different countries. There are different ways in which this problem can be solved. There are certainly educational programs, for example, for judges, which exist in many countries. There are procedural means through which the courts can organize a discussion with the experts, the economic experts in particular, in such a way that the crucial issue will come to the fore. And there are institutional means, and there I mean the possibility to create sections or chambers which hear all the competition cases, because through the repetition of cases, they eventually acquire quite a bit of knowledge about what competition law is all about. Now, this is a complicated issue because one may want to avoid the fact that some judges become too specialized, but there are ways, without specializing necessarily a chamber, at least to make sure that the same chamber receives a sufficient number of competition cases to be able to develop a culture. Ladies and gentlemen, let me stop here and state again that those recommendations should be considered, but should not detract us from recognizing the excellence of the work which has been accomplished by the Superintendencia in difficult budgetary circumstances during its first decade of existence. Thank you very much.
Agradecemos esta participación.
We're very grateful for those words. And now we would ask Mr. Danilo Silva, the Superintendent of Market Power Control, to go ahead and give his presentation. Go ahead, sir. Thank you, Valeria. Mr. President of the Republic of Ecuador, Mr. Lenin Moreno, Mr. Frederick Jenny, Chairman of the OECD Competition Committee, Ms. Adriana Lavalle, IDB Country Representative in Ecuador, Mario Umaña, IDB Competition Expert, Mr. Felipe Irarazabal, External Consultant for the drafting of the review, members of the team of the OECD and the IDB, representatives from competition agencies, members of the team of the Superintendency of Market Power Control, distinguished guests here with us today. Today, the 31st of March, is without any doubt a very important day for the country. After 16 months of exhaustive technical work at the highest levels, the OECD and the IDB had given us the result of the competition law and policy peer review. We're very excited about this, very satisfied as well, but above all, we feel a great sense of responsibility because this is a meaningful step in that challenge that my team and I know is part of our job in the superintendency, which is to guide and strengthen the competition regime in Ecuador. And the political context was ideal for this happening right at this moment and to create some structural changes. The commitment from the executive was to respect the independence of the institutions that make up the different state functions. That independence has given us the ability to create a path that has turned us into a technical competition authority, which is based on the principles of transparency and the respect and guarantee for due process. And with this conviction, in September of 2019, during the Latin American Caribbean Forum for Competition that took place in Honduras, we presented Ecuador's candidacy to take part in the peer review and to submit one's competition laws and competence to revision by other members of the international community is a decision and a commitment taken by a country, and proves once again the aspiration that we have to fulfill the best practices in the implementation of law and in the principles and policies around competition. And to be able to do this has been possible thanks to the professionalism of the superintendent's team, which has collaborated in a decisive way in drafting this review. Of course, our thanks also go to the team of consultants who for months were carrying out an extensive amount of review of statistics, documents, legal and regulatory frameworks. Moreover, they carried out interviews to representatives from different institutions, business associations, chambers of commerce, institutes, and universities throughout the country. And special thanks to the evaluating agencies from Canada, Panama, Spain, and Uruguay that participated in the preliminary report. Likewise, we would like to express our gratitude to the peer agencies that have already gone through this path in the past and that have shared their lessons learned to improve the competition framework in our country and to contribute to the economic growth. Throughout this process, we have always wanted to facilitate access to information and to related stakeholders so that the consultants were able to carry out their work in the most fluid way possible. Since the beginning of my having taken over this role, and as we saw this review going on, we've taken some first priority steps to strengthen the institution. Just let me give you some examples. In September of 2019, we presented our new leniency program via the reform of the procedure for granting fine exemption or reduction benefits. A program, very strict, which tries to guarantee transparency of benefits and efficiency in the analysis of requests, and above all, confidentiality and legal security throughout the entire process. This was a subject which Ecuador had to deal with still. It was necessary in order to change the institutional image. We improved the pre-merger notification process in order to optimize time for those operations which, fulfilling set out technical criteria, would have a less potential for creating negative effects on the market. We in promotion are working together with INDECOPI in order to come up with a whole methodology for analyzing regulatory barriers to analyze demands, requirements, limits, or prohibits that any entity or public sector body would put in place that would have the effect of either conditioning, hampering, or blocking access, the maintenance within, or the working within the market by any economic operators. We have tried to come up with precedents in terms of unfair competition as well as the nature of the law itself in order to develop the processes of research or investigation. We have carried out a constant analysis of relevant doctrine and of international case law without losing sight of the regulatory setup which was adopted by the lawmaker. We would like to promote we shall be putting specific legislation on this topic forward. We're also working to strengthen the technical and procedural analysis in order to reduce permit times for those transactions which are not harmful to competition and simultaneously focus resources and tools on those operations which do have higher potential risks so that the measures taken are appropriate and are for the benefit of market competitiveness. We are trying to strengthen transparency in merger control procedures, efficiency in analyses, and predictability for economic operators by coming up with technical communiques, manuals, and guidelines that take on board the best international practices in, of course, strict adherence to Ecuadorian regulation. For the prosecution of restrictive agreements and practices, the challenge is to issue a set of rulings which would make administrative precedent about the detection and investigation of agreements in the case of hardcore cartels, which would lead to a deterrent sanction for economic operators, which would give us the chance to consolidate the institutional reputation of the country and create a competition culture in the country. Moreover, we will continue to coordinate actions with regulatory and supervisory bodies to reduce information processing time so that one can confirm or rule out a particular anti-competition agreement or practice. We are trying to create incentives so that operative economics can have access to the leniency program, thus restoring confidence in the institution with respect for confidentiality of information and legal safety. The first instance resolution commission is committed in creating clear and widely substantiated precedents, thanks to which we would be able to offer legal security to all market actors, as well as being able to resolve issues that have to do with legal and economic standards, respecting due process, using comparative law as a basis of analysis, and above all, trying to line up or harmonize the different regulatory bodies that exist within Ecuador's legal and economic system. The greatest transformation which has been reached in this management can be seen in the work done around competition advocacy. The flexibility, which is part of that process of advocacy, has given us the chance to be able to work with regulatory bodies and economic operators in order to foster a policy of competition which favors economic activity. In this area, we could talk about three major axes: promotion, prevention, and regulatory improvement, basic aspects in order to create markets which are more competitive and inclusive, in which we can find innovation. In terms of promotion, we are trying to find a position of the institution as the competition authority, as well as in what way, to see what benefits are part of this competition policy as a basic component for economic development. Prevention will focus on market diagnosis and detection of market distortions, which could be corrected by a regulatory or institutional reforms or by control carried out by the superintendency itself. The best way of regulatory improvement has its objective reaching the proper balance between economic freedom and protection of general interest via modern, intelligent, reasonable, and proportional regulation, which does not unnecessarily hamper economic activity. It does not create entry barriers which would affect competitors. a recognition to the work that's been given for the by the President of the Republic for the reform of the regulation for the application of the law, which introduced procedural and substantial changes in the merger regime on abuse of market power and restrictive power, and carried out changes in sort of concepts which we had been talking about within the competition authority for the last few years. In general, these reforms all observe the best international practices, such as those issued by the OECD. Reform also rearranges regulatory authority, making it possible for the superintendency to carry out authority that had been in the hands of the executive, thus strengthening the authority of the agency and to be able to carry out directly modifications and implement new methodologies, for example, those that have to do with determining the amounts of sanctions to be imposed by the institution. This new methodology, well, we're hoping that this will become a deterrent agent to the possible committing of anti-competition activity by economic players, and would also be an incentive to mechanisms which are contemplated by law, the commitments to stop and the leniency program. I would like to say that this also strengthens the transparency and the publicity that we're working with. And so a few conclusions about where the opinions can be published in terms of the guides, technical criteria, market studies, and the resolutions that are admitted as well, always protecting that information which is considered to be confidential in keeping with what is set out by the Constitution and by law. Today, our task is to take on leadership in the application of the recommendations which have been made by the OECD and the IDB that require coordinated effort of the legislative, executive, and judicial bodies, as well as other institutions whose role concerns transparency and social control. We are convinced that the peer review will be useful to support institutional needs, the requirements for budgetary allocation increase, regulatory reform, and would encourage other governmental organizations to promote a culture of competition in the country, but above all, to forge a path together towards building efficient markets that benefit everyone. We warmly welcome the observations and recommendations that are set out in the peer review. For the current management of the superintendency, and as part of institutional objectives, it's absolutely essential that there be a true financial administrative independence that allows for us to make the most of the talent of technical officers with careers that ensure staff continuity and institutional know-how. Likewise, timely budgetary allocation means timely performance of technical activities with the speed that those investigations require, also ensuring compliance with regulatory timelines. I would once again like to emphasize our maximum engagement with taking fully on board the final recommendations of the peer report, that we would work as a country in a common objective to continue working on even better competition regime for the welfare of our citizenry. We also resoundingly support the excellent work being done by the other countries in our region whose support we count on. Thank you very much.
Muy amable, doctor Silva, por su intervención. En este momento continuamos con un mensaje del señor presidente constitucional de la República del Ecuador, Lenín Moreno Garcés. Adelante, por favor.
We have a message from the President of Ecuador, Lenín Moreno Garcés. Mr. Frederick Jani, Chairman of the OECD Competition Committee, Ms. Adriana Lavalle, IDB representative in Ecuador, Mr. Danilo Silva, Superintendent for the Control of Market Power, OECD and IDB team members, representatives of competition agencies, Ecuadorians. Today, we receive the result of the peer review of Ecuador's competition law and policy carried out by the OECD and the IDB. This review, voluntarily requested by the Superintendency for the Control of Market Power in 2019, will allow for the alignment of Ecuador's competition policy with the highest international standards in order to promote more efficient markets for the benefit of all Ecuadorians. This exercise strengthens the country's image in the international community and reflects our commitment to consolidate public policies towards our integration into the OECD. We receive the recommendations issued with absolute responsibility and commitment, since they will require the articulated work of 4 of the functions of the state. It is worth mentioning that in November 2020, by means of Decree number 1193, the executive partially modified the regulations for the application of the Organic Law on Regulation and Control of Market Power in order to strengthen the competition regime. With this reform, the article that prevented the superintendency from exercising its regulatory powers was repealed. Now, the control body may issue the technical regulations it deems necessary to adequately perform its work. Likewise, in the area of merger control, we have incorporated a two-track system so that only those mergers that require special attention due to their possible impact on the market are analyzed in depth in the second phase, while those other mergers that, after a preliminary analysis, would not have an impact on the market can be approved in a expeditious manner in the first phase to promote the development of the productive activity generated by the private sector. There are other reforms that need to be implemented in order to further improve our system. For example, the one that provides that collusive conducts in public procurement processes and public tenders may be considered as restrictive agreements and practices by object. This reform is crucial to strengthening the fight against anti-competitive acts, therefore illegal, and to contributing to the protection of public resources. We are certain that this is one more step towards guaranteeing the legal certainty enshrined in our Constitution. Of course, there are still actions to be carried out by all state functions in order to comply with the recommendations contained in this report. With the legislative function, the law must be revised to clarify the powers of the superintendency so that its sole mandate is to act as the authority for the promotion and protection of competition, while reinforcing in other regulatory bodies those functions related to consumer defense and protection against unfair competition, as well as the ones related to fine categories. In the judicial function, it's necessary to strengthen the capacities and expertise of the judiciary in competition matters with a view to guarantee sound technical decisions by the courts. And finally, within the transparency and accountability function, there is a need to refine the capabilities of our institutions with respect to the competition regime. From the very beginning of my term in office, we have respected the independence of the state's functions as a guarantee of democracy. And here we have a clear example of this. I congratulate the team of the Superintendency for the Control of Market Power on the decision of submitting our competition law and policy to this international evaluation, because it will certainly bring great results. We are moving forward with firm steps with the aim of strengthening the competition regime and building efficient markets in our country. Thank you very much.
Futuro.
Agradecemos el mensaje del señor
We're
presidente.
very grateful for the message we've gotten from the President. And thus, the Superintendency for Market Power Control would like to thank you for all having participated in this event, a milestone in the consolidation of Ecuador's competition regime. And this, ladies and gentlemen, brings today's event to a close.